The following IWLA webinar, Legal Issues in the 3PL and 4PL Relationship and Protecting Your Business in the Age of Electronic Warehouse Receipts, was recorded on January 30th, 2014. All information is accurate as of this date. Hello and welcome to IWLA's Warehouse Legal Webinar, Protecting Your Business in the Age of Electronic Warehouse Receipts and 3PL and 4PL Relationships, scheduled to run between 11 a.m. and noon Central. My name is Joe DeGuzman, and I am the Senior Coordinator of Member Marketing for IWLA. Today it is my pleasure to introduce our featured speaker, Mr. John Horvath. Mr. Horvath is a trial lawyer whose practice is focused on representing public warehouse operators and other bailees on claims, lawsuits, and negotiations regarding storage agreements. John has represented the IWLA on special projects, including the 3PL and 4PL agreements and demurrage and detention issues. John is also counsel to the International Association of Refrigerated Warehouses on warehouse law and transportation law issues, and author the Terms and Conditions, which is currently approved by that association. Before we begin, I'd like to quickly address protocol for the webinar. During the webinar, all participants will be placed in lecture mode and all participants' lines will be muted. To collapse the interface window on the right-hand side, please click on the orange button with the arrow pointing to the right. If you minimize that application instead of clicking that arrow, you will no longer see the presentation. At the end of the presentation, there will be a Q&A session. To submit those questions, use the questions or chat box in that user interface window on the right-hand side. If you have any technical issues, please use that same function so I can respond to you directly. This presentation will be distributed in PDF format by email either later this afternoon or tomorrow morning. With that, I'd like to hand over the presentation to John. John, go ahead.
Thank you, Joe. Good morning, everyone. Thank you for the opportunity to address you on these very important issues. I was asked to come up with a topic for today's presentation, and in the recent past, I have been involved with a few 3PL, 4PL issues, not only negotiating the 3PL, 4PL agreements, but also representing a warehouse operator who had a problem with the 4PL and the customer. And the electronic warehouse receipts, will go into that, and that'll be the shorter portion of the presentation. But the reason I selected that is most customers now are reluctant to have the warehouse operator issue hard copy warehouse receipts, not necessarily because they're concerned about destroying the forests, but more because they don't want to have the hard copies hanging around their offices for 3, 4, 5 years. Anyway, we will address these issues in the opposite fashion in which they were identified on the presentation that you received before coming here this morning. First, we'll talk about the 3PL, 4PL relationship, and then we'll talk about the electronic warehouse receipts. And as Joe said, we'll have an opportunity at the end of the presentation to ask questions. I received a phone call yesterday from a lawyer who represents a warehouse operator who's involved in the 3PL, 4PL relationships with various entities. And the lawyer called me not because of any announcement he saw from IWLA regarding the webinar I was doing, but he researched and found my name some way else. In any event, the lawyer, like many people, had a misunderstanding as to who the players are in the 3PL and 4PL relationship. So that's why I figured I would start off with identifying what is the 3PL. 3PL is the partner in the 3PL, 4PL relationship that has the bricks and mortar, that has the truck. It's the one that performs the warehouse or transportation services. And the 3PLs can be warehouse operators, carriers, freight forwarders, property brokers, anyone who actually provides these services. In the 3PL, 4PL relationship, the 4PL is the entity that has the customer, doesn't have the the bricks and mortar, doesn't have the trucks. It just has the customer, which is very important. 3PL, 4PL is not a new concept. It was a term that was coined by Accenture in the late 1980s. And essentially, a 4PL is a non-asset-based 3PL. The nature of the 3PL, 4PL relationship is to serve, ultimately to serve the customer. It's a partnership between the 3PL and the 4PL to provide services to the customer. As in any legal relationship, there should be written agreements between the parties. There should be a written agreement between the 3PL and the 4PL, defining the respective rights, duties, and obligations of the 3PL and the 4PL. And there should be a separate agreement between the 4PL and the customer. Now, that's what we're going to talk about this portion of the agreement. Let me tell you, before we get into that, a bit about the situation that I handled about 3 months ago for an IWLA member who entered into a 3PL, 4PL relationship with a company. In that particular case, the 4PL happened to be some sort of a consultant. It wasn't a carrier, wasn't a freight forwarder or broker. He was a consultant and had less assets than most property brokers have. Well, the contract got negotiated between the warehouse operator and the consultant, and it was supposed to be a 16-month term, and there were supposed to be guarantees of certain minimum monthly activity, and that got incorporated into the agreement between the 3PL and the 4PL. That, you know, here's what it is. You're going to be here guaranteed for at least 16 months, and we're going to receive no less than $5,000 or $10,000. No, I guess it was more than that. It was $20,000 a month in charges, storage charges, guaranteed minimum storage charges. And so that gets into the agreement between the 3PL and the 4PL. Well, what happened is the 4PL didn't have that agreement with the customer. So when the customer started directing the goods to be shipped out of the warehouse about a third of the way, well, let me back up. In reliance upon this, the warehouse operator moved product, reconfigured racks, incurred other expenses totaling about $100,000, based on the fact that this would be a 16-month deal and he'd be getting at least $20,000 a month on the charges. So when the customer started directing the products to be shipped out of the warehouse operator says, "Hey, wait a minute, you're going to be on the hook for the guaranteed minimum." Started billing the 4PL for the guaranteed minimum, received the payments for the guaranteed minimum for 2 months, and then all of a sudden the 4PL says, "Oh no, the customer says he's not going to do it." So he wound up with a dispute between the 3PL, 4PL, and the 3PL and the customer. And ultimately, I had the warehouse operator enforce a warehouse lien. It was questionable whether the warehouse operator had the entitlement to the warehouse lien, because the agreement was a bit fuzzy on that, but I took the position that, yes, we have the lien and we're going to enforce and we're going to sell the stuff. Ultimately, I got the warehouse operator most of what he thought he was entitled to. The problem with that particular situation is the warehouse operator and the 4PL didn't dot the I's, cross the T's on their agreements. The big concern for the 3PL is the 4PL had really no assets, so if the 4PL promised something that the customer was not prepared to deliver on, the 3PL's contract was with the 4PL, and the 4PL didn't have any money to fulfill any obligations to the 3PL. So the contracts between the 3PL and 4PL and between the 4PL and the customer are really critical. Now, first thing we've got is a situation where the 3PL, 4PL agreement is the warehouse receipt, and that includes the contract and rate quotation. And in that, let's see, what am I doing? Okay. Let's go back to this. Partnership served. Okay. In the agreements, you want to make sure that you address the standard of care, and then we're going to talk about the standard of care. We're going to talk about contract issues, both as to the where the warehouse receipt is the agreement. We're going to talk about the contract issues where the there's a different agreement other than the warehouse receipt terms and conditions. We'll talk about insurance issues, and then we'll talk about the electronic warehouse receipts, and then we'll have questions. In the standard of care provision, the 3PL is the bailee. The 3PL is the one who's storing the goods at the warehouse, and we'll just talk about warehouse operators as 3PLs as opposed to the common carriers who also can be 3PLs. But the warehouse operator is a bailee, generally as a bailee held to a reasonable care standard. As we all know, under the Uniform Commercial Code, you can agree to exercise a standard of care higher than reasonable care. That implicates problems with your insurance, your warehouse legal liability insurance coverage, however. Now, the 4PL can also be a bailee. It can be an agent and can be something other than a bailee and an agent. Let me see a show of hands. How many of you have entered into agreements because you needed some overflow warehouse space on a temporary basis, entered into an agreement with one of your friendly competitors to store products for one of your customers at that friendly competitor's warehouse? To the extent that you've done so, you have been in the role of a 4PL because you had the customer's goods, you didn't have the space to store them, and you entered into this 3PL, 4PL agreement with your friendly competitor. So the warehouse operators can be 4PLs under certain circumstances, as well as the motor carriers, freight forwarders, and brokers. Generally, the bailee is going to be held to a reasonable care standard if he's acting as a 4PL, and if he's an agent, should be held to a reasonable care standard, and depends on what the other status is, what sort of standard of care the 4PL will be held to. Now, where the relationship between, or the agreement between the 3PL and the 4PL is the warehouse receipt or contract and rate quotation, the 3PL really has no issues as long as the 3PL is not using a warehouse receipt that has this prefatory language: property will be accepted by this corporation for storage only under the following terms and conditions, subject to the provisions of the Uniform Warehouse Receipts Act. Uniform Warehouse Receipts Act predated the Uniform Commercial Code, which came into being in 1964. It's not the best terms and conditions. Alternatively, there will be problems if the warehouse receipt terms and conditions are those that have been approved and adopted by the Association of Railroad Warehousemen on October 1, 1928. I have two clients who have this on their, or who had this on their terms and conditions, and the terms and conditions were very bad. As long as you are using the standard IWLA terms and conditions or IARW terms and conditions, you should be, as a 3PL, fine. Now, if the agreement between the 3PL and the 4PL is the IWLA or IARW standard terms and conditions, what problems, if any, does the 4PL have? Well, the 4PL is going to receive the warehouse receipt from the 3PL, and that's the contract between the 3PL and the 4PL. And the 4PL is then going to issue some sort of a warehouse receipt to the customer. The 4PL must identify the storage location, must identify where those goods are stored. For those of you who have contracted or entered into an agreement with your friendly competitor to store your customers' overflow products at that warehouse, some of you don't want to identify that you're storing the goods for this customer at a different location. That creates very bad problems for you. Under the law, the property of the customer has to be stored at the location identified on the warehouse receipt or storage agreement. If it is, and if the agreement says that you're held to a reasonable care standard, then you're only going to be liable to the customer for loss or damage to the goods if the damage or loss occurs as a result of your failure to exercise reasonable care. If, however, you store the goods at a location different from that identified in the storage agreement or warehouse receipt, and you don't disclose that to the customer, then you as a bailee will be liable for anything that happens to those goods, whether it's due to an act of God or due to your negligence or due to the negligence of a third party for which you're not responsible. So if the goods are stored at a location that the customer has not authorized and you don't disclose it in your warehouse receipt or storage agreement, you will be absolutely liable for any loss that occurs to those goods. So you need to identify the location of storage. You need to, there are provisions between the 3PL agreement, 3PL, 4PL agreement need to be substantially identical to the provisions in the 4PL customer agreement. And on standard of care, obviously, you need to have a reasonable care standard. The 4PL is only going to be liable to the customer in the event of negligence because that's what the standard is between the 3PL and the 4PL. Limitation of liability, that needs to be identical or virtually identical. If you're using the IARW terms and conditions, that has a provision for the lesser of 4 different alternatives: replacement cost, fair market value, 50 times base storage rate, or 50 cents a pound. IWLA has a fill in the blank, and let's say the 3PL fills in 100 times the base storage rate, and the 4PL has is using IARW terms and conditions and has the 50 times base storage rate or 50 cents per pound. The limitations aren't the same. So it could wind up that the 4PL may be having to pay the customer more by virtue of a limitation of liability, which requires the 4PL to pay more than the 4PL is going to get from the 3PL in the event of loss or damage for which the 3PL is liable. Time periods. Time periods in the for filing claim and suit in the IWLA terms and conditions. Claim is 60 days. Suit is 9 months. IARW is the same, 60 days, 9-month time period. The problem with that, if both the 3PL, 4PL agreement and the 4PL customer agreement have the 60 day for claim, 9 months for filing suit, the customer could file a claim with the 4PL on the 60th day, and unless the 4PL immediately files notice of claim with the 3PL on that 60th day, the 4PL could be SOL because he would have failed to file the claim within the 60-day time period. Same situation with the 9-month time period for filing lawsuit. That's more likely to be enforced by the courts than the 60-day time period for filing claims, although we have had a few cases where these courts have enforced the 60-day time period for filing claim. So if one is acting as a 4PL, you want to make sure that the time period for the 4PL to file claims against the 3PL is longer than the time period for the customer to file the claim and suit against the 4PL. warehouse time for payment. Usually the time for payment is 30 days. It's important also who's going to be making the payments. I on behalf of IWLA, negotiated the Landstar 3PL, 4PL agreement, and in that agreement is an unusual 3PL, 4PL agreement because the burden is on Landstar to pay the 3PL within 30 days. And Landstar, during our negotiation, said, yeah, we're going to do that. We're going to, we're not waiting until our customer pays us. We're going to go, and if we have to borrow the money, we'll borrow to pay the 3PL. Not all 4PLs are going to be doing that. Mostly what they're going to try and do is say that we'll pay you after we get paid. And you don't have much control over the customer. So that kind of dovetails into the next issue, warehouse lien. Will you have a warehouse lien in the 3PL, 4PL relationship? The warehouse lien is a very, very important tool just in normal warehousing. I'm dealing right now with bankruptcy issues for a few warehouse operators, and as long as the warehouse operator has a general warehouse lien, if the customer goes bankrupt, the warehouse operator is protected, will get paid for those pre-petition charges, and will not be subject to having to repay any funds received by the warehouse operator within 90 days prior to the filing of the bankruptcy. Those are considered to be preferential transfers, or potentially considered to be preferential transfers. So if the warehouse lien will prevent those things from happening. It will require the warehouse operator to be paid, and it will prevent the warehouse operator from having to repay any money that it received within 90 days prior to the filing of the bankruptcy. Now, in the 3PL, 4PL situation, many 4PLs refuse to allow the 3PL to have a warehouse lien. So if you don't have a warehouse lien and you don't have any direct contact with the customer, you're going to have a tough time getting paid. So that's why it's really important to try and fight for the warehouse lien. Just negotiated a 3PL, 4PL agreement a week ago. I'm representing the 3PL, the warehouse operator. And this was kind of a slam-bam situation. I got contacted about the 3PL, 4PL agreement, I think the day that the warehouse started receiving products for storage. And so we negotiated knowing that we've got this expensive electronic stuff in the warehouse. But it was not just supposed to be for this one customer. It was going to be for multi-customers, and it was going to be for several different locations throughout the country for this particular 3PL operator. So what we negotiated, the 4PL said, no, we don't have any warehouse liens with any of our customers. They won't let us do it. That just sounds to me like the issue was never raised by the 4PL with the customer. And so what we did is we inserted a provision that allows the warehouse operator on a customer-by-customer basis to determine whether it will have a warehouse lien or not. So it doesn't have a blanket warehouse lien. Doesn't have a blanket warehouse lien on all of the customers that the 4PL is going to bring to the 3PL for services, but it will be done on a customer-by-customer basis, and the 3PL can pick and choose which ones it needs to have a lien on. But the lien is very important. 3PL, 4PL contract issues. If the agreement between the 3PL and 4PL is not the IWLA terms and conditions or the IARW terms and conditions, but is a contract that is presented by the 4PL, then as a 3PL, you need to review it just like you would any other customer agreement. It would also be helpful to review the contract between the 4PL and the customer so that you can see what obligations the 4PL has to the customer, and you can at least be aware of those and try and contract for those particular issues in the 3PL, 4PL agreement. Incorporating terms in the 3PL, 4PL agreement, you need to be careful about incorporation by reference. Terms can be incorporated by reference in this pop-up down in the lower right. 4PL may issue and 3PL may accept a receipt or other writing, which together with the terms of this agreement will constitute the entire contract for services. That's a provision I took from the 3PL, 4PL agreement that I negotiated a couple years ago. What that says is that the 4PL can issue a receipt or other writing, and that becomes part of the agreement between the 3PL and the 4PL. So what essentially that does is the 3PL and 4PL sign off on a written contract, but now the 4PL has the right to change that contract unilaterally by issuing some other writing to the 4PL, excuse me, to the customer, which is going to bind the 3PL. So you don't want to enter into any sort of an agreement like that that allows the 4PL unilateral discretion to change the ground rules. Many customer-prepared agreements that I've reviewed, this is not necessarily in the context of 3PL, 4PL, but many customer-prepared agreements incorporate by reference the customer's standard operating procedures, sanitation manual, you name it, those things can be incorporated. And as long as the incorporation is limited to what has been provided to you at the commencement of the storage agreement, that's fine. But what the customers do is they want to have the right to unilaterally change those sanitation manuals, operations manuals, and that sort of thing without your input, which can be a big game changer and can put you at risk of having to incur substantial expenses in order to comply or run the risk of being in breach of contract. Three-party agreement. The 3PL, 4PL agreement really is a three-party agreement because it also incorporates to some extent the 4PL customer agreement. One of the things that we did with Landstar is we had the customer sign off on a separate exhibit which identified the limitation of liability provision, which identified that the 4PL actually did have authority from the customer to enter into this 3PL, 4PL agreement because the 4PL, under the law, an agent cannot establish its authority to act, so the agent would be the 4PL, and he can't establish his authority to act. Having this separate agreement that didn't have any reference or identify any of the rates or charges, but simply identified the limitation of liability provision. If there were certain, like in our example with the warehouse operator who thought he had a 16-month agreement and there was a minimum guaranteed charges, something like that should be put into a separate agreement that's signed by all three parties. That way there's no dispute as to what the terms are, and those are really important terms. Limitation of liability. This is an actual provision. In addition, 3PL shall be responsible for claims for loss or damage to cargo in an amount equal to the warehouseman's legal liability and or cargo legal liability amount that 4PL owes its customers as specified in the applicable 4PL contract of carriage. Well, that limitation of liability is going to be different from the 3PL's, the warehouse operator's normal limitation of liability. That's why it's important to see the contract between the customer and the 4PL. Standard of care provision. As the 3PL, you want to make sure that you're not agreeing to a higher standard of care than reasonable care, because that will void certain of your insurance coverage, your warehouse legal liability insurance. This particular provision, 3PL agrees to indemnify and hold 4PL harmless against all claims which may arise in relation to the services provided under the terms of this agreement, including property damage, cargo loss, public liability for injury or death to persons, and any violations of law, except to the extent such claims are solely caused by the negligent acts or omissions of 4PL or its employees. What does that provision do? That provision requires the 3PL to be absolutely liable for anything that happens to the goods or any injury to the public unless it's due to the negligence or omission of the 4PL. So it's essentially an absolute liability provision, and that 3PL will have coverage problems if loss or damage occurs due to an act of God. It's going to be liable to the 4PL under this agreement. Lien provision. There are artful ways that 4PLs and customers will attempt to prevent the warehouse operator or 4PL from getting a warehouse lien. And here's one of those provisions. This agreement, including the appendices, represents the entire agreement existing between the parties relating to the subject matter hereof and supersedes any prior agreement between the parties, written or oral, relating to the subject matter of the agreement. No change to this agreement anyway. So this is the integration provision. This agreement is the only thing that applies. The warehouse operator in this particular case, the 3PL, thought that because he was issuing warehouse receipts that contained his lien, in addition to signing this agreement, that the lien provision on the warehouse receipt was enforceable. Well, there was nothing in the agreement that allowed or required the 3PL to issue warehouse receipts, and therefore the terms and conditions on the warehouse receipts that he issued without any authority under the agreement were not part of the agreement, and therefore no warehouse lien. Claim and payment issues on the 3PL, 4PL contract, essentially the same thing that we talked about before. They need to be addressed in there. The 3PL needs to have the 4PL submit written claims for loss or damage to the goods within a timely basis, and then they need to address what the payment, who's paying, when they're paying, and all that sort of thing. 4PL and customer contract issues, basically the same things we were just talking about between the 3PL and the 4PL. Insurance issues. In the 3PL, 4PL relationship, as long as the 3PL hasn't agreed to exercise a standard of care higher than reasonable care, there should be no insurance coverage issues under the warehouse legal liability policy. The 4PL, on the other hand, has lots of issues. Is there coverage for loss or damage to the customer's goods at the 3PL's facility? That's kind of an open question, and the reason for that is the warehouse legal liability policy is the policy that all of you have that provides you with indemnification for loss or damage to customer goods that occurs at your warehouse facility. But the goods are at a different location. All warehouse legal liability policies require you to either be the warehouse operator or bailee or a combination of the two. You certainly are not the warehouse operator for goods that are at the 3PL. You might be a bailee. In the 3PL, 4PL agreements that I've negotiated where I represent the 4PL, I make sure that I put in enough control requirements so that the 4PL is in absolute control over those goods while they are in the 3PL. And the reason for that is a bailee under the law is someone who has care, custody, or control of property belonging to a third party. Therefore, if the agreement is very heavy on the control aspect, I think and the 4PL identifies the 3PL location as being an insured premises, I think the warehouse legal liability insurer would be hard-pressed to deny coverage to the 4PL. The 4PL should verify the 3PL's warehouse legal insurance coverage, should get an actual copy of it, review it, because Not all warehouse legal liability policies are the same. There are some of them that have 2 pages of exclusions, and there are others that have just 3 or 4 exclusions. So you need to make sure that the warehouse legal policy that the 3PL has is a good, solid warehouse legal policy. One of the other considerations is let's see, additional insured. The 4PL may want to become an additional insured on the 3PL's policy. I skipped over a couple of things here. Warehouse/Bailey, that goes to not all warehouse legal policies are created equal. Some of them, the broader ones, provide coverage for your liability as a warehouse operator or Bailey. The more restrictive ones only provide coverage for your liability as a warehouse operator. Bailey can be a cross-docker. You're not acting necessarily as a warehouse operator. You're acting as a Bailey. Some of the warehouse legal liability policies require the issuance of warehouse receipts in order for coverage to be applicable. The better ones do not require the issuance of warehouse receipts and may only require that there be some sort of an agreement between you and the customer or 4PL. Insured premises is another big issue on warehouse legal policies. Sometimes the insurer, I had this one situation where a warehouse operator was going to be handling some drop trailers and wanted me to prepare a drop trailer agreement. I did, but I asked him to show me his warehouse legal policy to make sure that he had coverage. Well, his warehouse legal policy defined premises as the building, didn't even define it as the parking lot. So the warehouse legal liability policy would only provide coverage for loss or damage to the goods in the building. And if drop trailers were dropped at the facility outside the building, there's no coverage for any loss or damage to the goods on the drop trailers. Warehouse, a 4PL may want to look into a warehouse errors and omissions policy. There are such animals out there. They do provide professional liability coverage, which is different from warehouse legal liability coverage, and may assist the 4PL in fully covering the liability exposures it may have. A commercial general liability policy may apply in certain situations and cover the 4PL for loss or damage to goods at the 3PL's facility. The reason for that is the commercial general liability policy will not provide coverage for loss or damage to the goods at the warehouse operator's facility because there's a care, custody, control exclusion. But that, if the 4PL doesn't have care, custody, or control of the goods at the 3PL's facility, that care, custody, control exclusion would not apply, and coverage might apply under the commercial general liability policy. That does it for 4PLs. Oh, that's good. I got all of 5 minutes to go. Electronic warehouse receipts and protection of your terms and conditions. I'm representing a warehouse operator in a lawsuit involving, let's see, $3.6 million worth of damage to goods. The storage agreement between the warehouse operator and his customer is the warehouse receipt. Each time the warehouse operator received goods for storage for the customer, the warehouse operator filled out the warehouse receipt and either faxed or emailed it to the customer. Sometimes they faxed and emailed the front side, or excuse me, they always faxed and emailed the front side. Sometimes they faxed and emailed the reverse side as well. And to the extent, and I've talked with other warehouse operators who only fax and email the front side, and that creates problems. Will the terms and conditions be enforceable? This portion of the presentation is designed to give you some strategies for making sure that your terms and conditions, which are really very important to you, are enforceable in the warehouse customer relationship. Problems with the issuance, fax and email. Sometimes front sides only, sometimes they'll fax the terms and conditions, and sometimes they will send the terms and conditions on only one warehouse receipt. Alternatively, we got no warehouse. The customer doesn't want any warehouse receipts. They just want EDI, the 943, 944 thing, or the customer does not want the hard copy at all. Just send us some, a delivery ticket or something. So we're going to first talk about fax and email. What I have done with some warehouse operators is I've prepared a written agreement for the warehouse operator to have the customer signed so that the warehouse operator can, without concern for the enforceability of the terms and conditions, fax and email the fronts only of the warehouse receipts. And this is some of that language. The important thing there toward the bottom, this is the first portion of that thing. Store waives any claim that the electronic warehouse receipt does not fully comply with the requirements of Article 7, Section 202 of the Uniform Commercial Code. That section says that the warehouse receipt doesn't take any particular form, but if the warehouse operator issues a warehouse receipt and doesn't include all of these different things, a person who's injured by the omission of these things can have an cause of action against the warehouse operator. So this last sentence is designed to prevent the customer from claiming that he or she was harmed by the failure to include certain of those required items in the warehouse receipt. Continuing on in this agreement that I prepared for the use in issuing warehouse receipts by EDI or fax, just fronts only, the parties agree that the terms and conditions under which companies shall receive, store, and/or handle the goods pursuant to this agreement shall be in accordance with company standard contract terms and conditions for storage. So what we're doing is we're incorporating by reference the contract terms and conditions, which are attached as Exhibit B and made a part hereof. In the event that any provision of the Exhibit B, the terms and conditions, conflicts with any provision of this agreement, the conflicting provision of Exhibit B shall prevail. Have the customer sign off on an agreement that contains those things and probably some other things as well. I think I've got a form for that in my emails, which I'd be happy to share with anyone who's interested. Have the customer sign off on that. You've got it locked away. You are free to send your warehouse receipts to the customers, and your terms and conditions will be enforceable other than in 2, 4, 5 states where the lien provision will not be enforceable. And the reason for that is Missouri, New York, South Carolina, Vermont, and Wyoming have not yet seen fit to adopt revised Article 7 of the Uniform Commercial Code, which was approved 10 years ago. 10 years ago. They haven't adopted it as yet. Obviously, they've got more important things to do. New York and South Carolina have introduced revised Article 7 in their legislatures this year. The reason that in those states you will not have the ability to have a warehouse lien is because under the original Uniform Commercial Code, Article 7, in order to get a warehouse lien, you had to issue a warehouse receipt that had, well, to get a general warehouse lien, you had to issue a warehouse receipt that had general warehouse lien language in it. And since you're simply incorporating by reference the terms and conditions, that may not be considered to be issuing a warehouse receipt with general warehouse lien language. So fax and email, incorporate another strategy for enforcing your terms and conditions is to incorporate the terms and conditions by reference. And most of you are using the standard IWLA front side of your warehouse receipt. If you revise it to state the following, the goods stored pursuant to this non-negotiable were received in apparent good order and condition, that's already there. pursuant to all of company's standard terms and conditions for storage, which are incorporated into this agreement by reference and will be provided to storer upon request. I think this is not as good as getting the customer's signature on the written agreement authorizing you to issue warehouse receipts by EDI or fax, but it's, this is okay. I mean, I really don't strongly recommend it. I strongly recommend getting the signed agreement with the customer, but this would hold up in a crunch. In those situations where the customer absolutely doesn't want any hard copy of EDI, have a written agreement with the customer. You've requested that we preserve the nation's forests by not issuing you tangible warehouse receipts, by your agreement, so on and so forth. A provision very similar to what we saw before with the authorization to issue warehouse receipts by EDI or fax. And I believe I have a form on that as well. Issue and hold. This is another thing. Okay, we will, you don't want the hard copy warehouse receipts, then what we will do, you have a written agreement with the customer. It says, we will issue the warehouse receipts, but we will hold them at our facility. And that will have the same force and effect as if we issued them to you, you received them, and understood the terms and conditions, and get the customer to sign off on that.
Thank you for listening to this IWLA webinar. For more information and for more webinars, please visit IWLA.com.